Welcome to Brotherhood Mutual's webinar, The Empowered Ministry, Preventing Sexual Harassment and Abuse. We're glad to have you with us. If you're experiencing audio issues, please check to make sure the volume on your computer speakers is turned up. If that doesn't resolve the issue, please let us know by choosing Send Question to Staff in the drop-down of the chat box on your GoToWebinar panel at any time. That Send Question to Staff option is also the way to ask questions of our panelists. You can send questions anytime as they come up during the webinar, and Kathleen will answer your submitted questions during the Q&A session at the end of the presentation. Your control panel may be minimized to the right of your screen. To maximize it, just click the red arrow. This presentation addresses general issues and principles. Nothing in this presentation should be understood to provide legal advice or create an attorney-client relationship. Participants are encouraged to consult with an attorney licensed in their jurisdiction to determine how locally applicable law applies to specific circumstances. This morning, you should have received an email containing a login link for today's webinar. That email also contains a link to the webinar slides. Feel free to refer back to the email to find those links if you haven't done so already. Today's webinar is being recorded. We'll post that file on our website and send you an email when it's available for download. Our presenter today is Kathleen Turpin, Vice President of Human Resources at Brotherhood Mutual. Kathleen is a well-respected, industry-known resource on employment practices for churches and other ministries. She joined Brotherhood Mutual in 1996 as a litigation specialist and now oversees the company's employment and human resources operations. She is a licensed attorney in Indiana. Now I'll turn things over to our presenter, Kathleen Turpin.
Good afternoon, and thank you for joining us today. Today we're going to talk a little bit about how to empower and protect your ministry by preventing sexual harassment and abuse. We're really going to cover two different things today, and I want to start off by clarifying the difference because a lot of times there is some confusion. The first thing that we're going to spend time talking about are guidelines for preventing sexual harassment. Sexual harassment is a situation, legally, it's between staff members. So we're not talking about what happens between a member of the congregation and a staff member, or between a volunteer or two volunteers. Sexual harassment is really involving employment, and it's involving a staff-on-staff situation. We're going to spend about a little less than half of our time talking about some guidelines for preventing sexual harassment, and then we'll move to guidelines for preventing sexual misconduct. Sexual misconduct is much broader. It's controlled less by federal laws and more by state laws and case law, and that is a much broader perspective because it deals with volunteers, it deals with staff people, it deals with a number of different individuals. And so as we cover this, I just want you to keep those two things in mind because they're very different. So the first one we're going to start on is preventing sexual harassment. Again, sexual harassment is dealing between staff members. And so in 2013, there were more than 7,000 sexual harassment claims filed with the EEOC, the Equal Employment Opportunity Commission. And reporting of sexual harassment is continuing to increase, especially in the ministry area. Some of this is probably because of the awareness in the news and on social media and some of the situations that have come up. So whenever there's an awareness raised in the media, it often involves an increase in reporting in ministries as well. Another challenge that we sometimes run into is that ministries often think that the First Amendment or the ministerial exception protects them. But even with recent case law, it's been very clear that when you're dealing with sexual harassment, neither the First Amendment nor the ministerial exception is going to provide protection if harassment actually took place. So let's start at the beginning and talk about what is sexual harassment. Sexual harassment is present whenever, and here there are a number of definitions, but the one I'm going to stick with basically says whenever there are either unwelcome sexual advances, and that could be either verbal or physical types of advances, requests for favors, such as if you don't do this, you may lose your job, or if you want to get a promotion, you need to do this, or other conduct of a sexual nature, verbal or physical. And then in addition to that, there has to be submission to this conduct, which either is a condition of employment, either stated, if you don't do this, you will lose your job, or implied. If you do this, then this will turn out wonderfully for you, or there may be some other benefits, or I know about this potential promotion or opportunity, and if you do this, then you will be in a good spot to get that promotion. It's also, or if this conduct is used to make employment decisions, or if it substantially interferes with work performance and creates, and this is what most people are most familiar with, an intimidating or a hostile work environment. When you think of sexual harassment, when you hear about it, there is a legal standard attached. And so our goal is not to, we may not always be able to prevent it, but we at least can have some guidelines. And so we're going to walk through all of these different guidelines. I'm going to read them, but then we're going to walk through them a little more individually. So you want to have a written policy about harassment and the definition. You want to communicate the policy. You want to follow the policy. You want to encourage employees to report. You want to investigate when you get a report. You want to document everything. And then if something takes place, you need to make sure that there's discipline and follow-up. So the first recommendation or guideline is to create a policy. Even if you are a small organization and you don't have a handbook with a bunch of employment policies in it, I would encourage you to at least have this type of policy somewhere where people, where it's communicated and people see it. And the harassment policy ought to include all of these types of statements. It ought to define what sexual harassment is, as I mentioned before. That provided a definition for that. It should state that harassment will not be tolerated. It should lay out clearly what is that reporting procedure. It should encourage employees to report. It should talk about what's going to be involved in the investigation process. It should make sure that those who report are going to be protected from some form of retaliation. It should assure confidentiality to a certain degree, to the degree possible. You don't want to ensure that there's going to be complete confidentiality. There are times that can't happen. And then discussing disciplinary action. And these are all the types of things that your policy ought to include. So if something was to take place and you are to receive a report that someone has been sexually harassed, what are some of the things that you would want to do? You have to do a thorough investigation process. So the first thing that you're going to want to do if you get some form of report to you, the first thing you want to do is you want to interview the victim and you want to interview the accused, not together. You want to interview them separately, you want to interview them privately, you want to take notes, and you should probably have more than just one person in there, whether that is another staff member, whether that is a board member, someone that's trustworthy, can maintain confidence, but you want to interview both of them, to get the victim's account and also the person who is being accused of the inappropriate action. You also want to make sure if there are witnesses that you interview those witnesses, and that's whether that's a volunteer, whether that's another staff person, regardless of who it is, you're going to want to do that. Then you're going to want to summarize all of this information into a written document, and that document ought to identify the timeline. When did the first thing take place? Was it a conversation? Was it a text? Was it an email? Was it a meeting? What was the thing that started the process? Then you want to stick to the facts. You only want to talk about what actually happened. You do not want to put in statements about whether you think somebody's being honest or they're not being honest. You want to make sure that you do that. Then the third one is you can include your observations about the demeanor or things that were raised. This person appeared very agitated, very defensive. This person was seemed very nervous. You can talk about some of that, or the way the person responded when you ask them questions. But you do want to avoid actually reaching a decision or stating any type of conclusion of guilt at this point. You don't want to get to that until the investigation process is complete. So the next thing that you would want to do in the investigation process is you want to research and collect documentation that supports the victim's account. It's not that you don't want to support documentation of the whole story. You can do that. But this is really, it's being a complaint that somebody is making. So you want to take it from their perspective. And you want to make sure that you have as much documentation as possible to see what happened. So often in a sexual harassment situation, it's basically two people's opinions of what happened or didn't happen. So sometimes you need to look to actual documentation before you actually make a decision or start deciding which way you're going to go. There are a lot of different ways that you can collect documentation, and this is just a small list. But obviously, if you can go in and look at emails that were transferred between the two individuals, if there are any previous complaints or comments, this is one of those, a lot of times in churches, there's a lot of turnover. And so you might want to make sure, if you haven't been there for a long time, you might want to go check and see, has there ever been a complaint made about this individual? Have you ever had an individual make or raise concerns about their discernment or how they handle specific situations? Also, any documents that a victim mentions. So if the victim says, well, I was texted, or they posted something on social media, or they sent me a copy of this article or this picture or something along that line, then you want to get as much of that information as you can. And then lastly, and this isn't necessarily the last step, but it is part of the investigation process, is identify in advance who your decision makers are going to be. Who's going to decide whether there's guilt there, whether it was an inappropriate action, what type of discipline is going to take place. You want to make sure that you have that identified so that you can communicate that to all of the parties that are involved. So now you get to the point of reaching a decision. As I mentioned earlier, decisions can often be, in these situations, a little bit of perspective, his perspective, her perspective. And while it's not always a he, she, typically that's the situation that you're dealing with. And so the answer is rarely clear-cut. High stakes are always involved. These are reputational type issues. It's a reputational issue for the victim and how they feel comfortable working in the environment. It's a reputational issue for the church. It's a reputational issue for the person being accused. Whether they did something wrong or they didn't do something wrong, there are high stakes involved. Terminating an employee, disciplining an employee, those all come with risks. So you certainly want to be careful and cautious as you walk through the process. Rarely, unfortunately, is everyone involved going to be happy with the result. Typically, somebody's going to feel uncomfortable. So I would encourage you to, if you have this type of situation, hire legal counsel to help walk you through the process. Having someone who can help make sure that you've crossed all your T's and dotted all your I's, collected all the information that you needed to collect, and made a balanced decision, recognizing what those risks are for whatever decision you make. Having legal counsel is a really good benefit for you. So we've talked about contacting local employment. Then you want your decision makers to review the evidence, and you're going to want to document that decision. Why did you reach it? A lot of times there's not going to be a clear-cut decision. You know, obviously it's not great, but it's a good thing if it's obvious. If somebody had something in writing and you can point to the fact that they did something wrong, you know, that makes it a little simpler to document the decision. However, a lot of times it's either A, you don't have any documentation, or B, maybe it was a situation where it was inappropriate. In ministry, we have a higher standard than the law, so maybe they didn't violate the law, but whatever decision or whatever communication they had or whatever they did was inappropriate from a ministry perspective, even if it didn't necessarily rise to the legal level of sexual harassment. But whatever you do, make sure that you document the decision, why you've reached the decision you've met, and what type of follow-up you're going to do, as well as the communication plan for the victim and the accused, because you're going to have to circle back around and advise them in writing and in person of what your wrap-up is based on the decision that you made. So now I'm going to walk through a few scenarios. So what happens if you get to the end and your decision group has decided that the harassment hasn't been substantiated? That doesn't mean that nothing occurred. It just means that you can't prove it, or you can't prove it to a level where you can take significant action. The first thing you want to do is you want to meet with that victim, and when you do that, you want to first clarify for them that you take harassment seriously, and that you want to thank them for the fact that they reported it, because you do need to know. You need to assure them that you're not going to retaliate against them for reporting. Then you need to go through and explain that you investigated, you took what they said seriously, and so you've investigated those charges, and if you're going to discipline the accused, you can let them know we're going to discipline the accused. You don't necessarily have to explain everything about what you're doing or what you're saying, but you do need to let them know that if there was anything found, even if it wasn't substantiated to the point where they're going to be terminated, if you are going to discipline them or set any guidelines or rules about the interactions those two individuals can have, you want to go ahead and clarify that. And so once you've done that, then you want to encourage the victim to report any further instances of harassment. And so that's if really you just can't substantiate that you know for sure that something did happen. If something was clearly substantiated and it's obvious that some type of inappropriate or sexual harassment took place, then you have a slightly different perspective. First, you want to make sure that you've consulted with legal counsel before you discipline anyone. Unfortunately, you can face legal consequences whether you terminate or you don't terminate, so sometimes you're caught in a difficult situation. If something is substantiated, though, some form of action needs to take place. Discipline may range from a written warning for a minor offense. Maybe they said something that was inappropriate. Maybe there was a miscommunication or a misunderstanding of what happened, but they crossed a line. And it may range all the way up to immediate termination, depending on what the circumstances are. And it's going to be very fact-specific. If the accuser isn't terminated, then you're going to need to make sure that you clearly explain what is acceptable behavior going forward, review harassment policies, and then you have a responsibility to continue to monitor that behavior. It's going to be uncomfortable if the two individuals continue to work for the same organization, especially in a church where often it's a smaller office. People are going to know what's going on, so you need to make sure that you make that environment safe. You also want to meet with the accused to discuss the investigation findings, review harassment policies with the accused, and counsel the accused on how to move forward as they're relating with the victim. One cautionary note about the Supreme Court, some Supreme Court rulings. A lot of times before that time, it was kind of viewed that, well, if the church or the organization didn't know what was going on, then they couldn't be held liable. But in 2001, the Supreme Court said that an employer could be responsible for sexual harassment even if no one in that organization was aware of it. There is a defense as long as no adverse action was taken against the victim. And adverse action means that that person was terminated, that there were some type of benefits removed from them, that they were put in a less desirable position, that they were somehow treated in a poor way. As long as none of that happened, there is a defense as long as the organization can show that it had a harassment policy, it was communicated to employees, it was followed, and that no action was taken. One other cautionary note, as ministry organizations, we often point to Matthew 18 in that you want to first go to the individual who has offended you and then bring a couple people and then bring the church, and there's this process with a whole goal of trying to reach reconciliation. That is a beneficial approach, but it is one of those things that when you're dealing with sexual harassment, you need to be very cautious because courts are not going to be very sympathetic if you basically send that person who feels like they've been harassed and say, you need to go meet with that person one-on-one. Instead, you should make sure that you're involved or that somebody is following up to get that side of the story. But it is inappropriate to follow the Matthew 18 principle directly when you're dealing with sexual harassment. You should never encourage the victim to confront the accuser personally first. That does also bring up when you've identified who the individuals are, who somebody would report harassment to, it's ideal if you can have both a male and female that they have an option to go to. This way, if it is a female who feels that they've been harassed, they may not feel comfortable going to a male senior pastor, especially if that person is a relative of them or maybe that they have a close relationship. And so you want to make sure that you give opportunities for them to do that. And part of that is also just this idea that you don't want the victim to be stuck in an uncomfortable position. So before I move on to sexual misconduct, I'm going to take a break, and I'm just going to go over and ask or answer some of the questions that maybe have come in. One was about whether or not we were going to talk about harassment of church officers or members of staff, and that is really what sexual harassment is about. Sexual harassment is involving staff members back and forth, and so it's not with somebody from the congregation, but it is actually staff members. Another situation is a little more maybe specific, but it has to do with a member of the church who kept telling someone that they had a revelation that this woman should be their spouse. And you know, is that considered sexual harassment? Well, it's probably it could rise to the level of sexual misconduct, but as long as the church member is not on staff, it wouldn't actually qualify as sexual harassment. Another one said, we are a small organization. Is there a boilerplate for sexual harassment policy for organizations between 0 to 50 members? And my answer to that one is yes. We actually have what we call Working Together that has sample policies. And those sample policies include some sexual harassment policies. Even if you're not a large organization, that's part of the reason we put those types of boilerplate sample policies out there so that you have something that you can look for. We have a question about we have security cameras in the pastoral offices. What's your recommendation to use them to prevent misconduct in critical situations? I think, again, anytime you have security cameras, as long as they're not in bathrooms, places where people are going to be in private type situations as far as being undressed or anything like that, you can have those security cameras and it's a way to reference them. Other than keeping them in fairly, I mean, the goal of a security camera would be that you have proof or you can document what did or didn't happen. Typically, those security cameras aren't going to talk about conversation. But going back to if you have a harassment claim and somebody says, I was in so-and-so's office and they sat too close to me and they started to stroke my back, you know, if you have a security camera, you can pull that up, and that's one of the documents you would want to get. And so then we say, another question is, how do we handle if we want to interview the victim, but they are uncomfortable with a second person during the interview? Well, unfortunately, I think it's appropriate to go ahead and insist on a third person there. I think that's beneficial for a couple reasons. For one, you have two people hearing the whole situation and hearing the story. You may give them some choice. For instance, if the one person who was going to be in there, if you were going to have two men in that room with a female who was complaining about sexual harassment, you might want to find another individual, whether that's a board member or somebody from the church or whatever it is, who can sit in there and is a female. But other than that, I think ultimately they have to be willing to share what they know. And if they aren't willing to share, it's very difficult for you to reach any kind of conclusion absent some really hard documentation. I'm going to answer one more question, and then we're going to move on to the sexual misconduct piece. It said, can we assume that staff indicates paid staff only? Typically, yes, when we're talking about staff, typically that's paid staff, because if it's unpaid staff, they're volunteers. But I do think you do have to be a little careful if you give other benefits to individuals, like maybe you're not paying them, but you provide some other benefit where they could potentially be viewed as being part of, quote, paid staff. So I don't know that it's not, but typically when you're talking about Title VII, it's employee on employee harassment. So I'm going to now move on to the other section. Now, guidelines for preventing sexual misconduct. This is a much broader scope, and this can deal with abuse against another adult, a vulnerable adult, a child, a teenager. So typically when you think of sexual misconduct, this is where most of the concerns tend to come, because we know that child abuse is impacting ministries nationwide. We know child abuse at Brotherhood. We see it. We see that there's been an increase in the number of types of claims that we see. Some of that may be awareness, but some of it is just that, that as it's gotten out there, people are more aware of what's going on, and they're more willing to say something if they feel like something is inappropriate. I will say that abuse has no regard for your church size, your denomination, or your location. It doesn't matter whether you're a church of 70 or a church of 700 or a church of 7,000 or 17,000. It doesn't matter. These types of things can happen. There are different risks based on your church size. A smaller church is more likely to know everybody and maybe less likely to believe when something happens. A larger organization is probably at risk because you don't know everybody, and there's more likely that somebody could get into a situation and not be fully screened. So it doesn't matter where you are, that can happen. Many ministries are just unaware of how often abuse takes place. And even though there is a greater awareness and more people are reporting, there are still many incidents that are never reported. People are too embarrassed. They don't think they'll be believed. Maybe there's, something that happened that made it really difficult. Sometimes it's where the relationship started at the church, but then whatever happened outside of the church. And a lot of times that's when claims come against the church. So here are just a few statistics. You can make statistics say whatever you want, but I think these are significant enough that it's important to highlight them. The church law and tax said that 70 allegations of church abuse are reported in churches every week. Now, this may be something small. It may not be sexual abuse. It might be a wide variety of child abuse, but that's still a large number. And I would tell you at Brotherhood, we see anywhere from 2 to 5 reports of abuse every single week. And again, some of these end up not being substantiated. Some of them end up not being severe, but it really doesn't matter. Our goal is to protect those who are in our care when we're at church. The National Center for Missing and Exploited Children said that 1 in 5 girls and 1 in 10 boys would be sexually victimized before they reach 18. And 96% of rape victims under 12 knew their abuser. So one of the challenges we run into at church is we are very trustworthy. We want to believe in people. We want to encourage people. We want to see the best in people. We believe in forgiveness and redemption. And those are wonderful things, but it is one time where we have to be aware of the potential out there. As we've talked about, as I mentioned, that the church is really a place where people look for opportunities. If they are a pedophile, they're going to look for some place where they're going to have easy access. And churches are at high risk. First of all, we rely on volunteers. I usually, when I speak in person, I will ask a question about how many of you have a long list of people dying to help out in children's ministry. And typically, you don't get very many hands. We're always looking for those volunteers, people who are willing to work with children. And abusers, they're looking for those types of opportunities, and so they view ministry as an easy target. We have a lot of children, we have a low number of workers, we have a culture of trust, and a lot of times there are no policies in place. And so these are all things that make us an easy target and a high risk. So one of the most effective things is to just make sure that you've thought about things ahead of time. And so creating a successful program doesn't have to be difficult. It shouldn't be cumbersome. The harder it is, the less likely it is to be followed. So you want to start off with very basic and easy to follow procedures. You don't want to have a 20-page document in there that a 20-page document that means that you're going to have to go through and they're going to have to fill out all of these different forms and remember everything. It's kind of like an employee handbook. If it just sits on the shelf somewhere and nobody reads it, it's not going to help you. You also need to tailor the procedures to your ministry. I talked before about the fact that sexual misconduct can hit a small church to a super mega church. The reality of it is not every church looks the same, and so every set of procedures, even the ones we talk about today, aren't going to apply the same across every ministry. You have to look at your ministry and think about what works for you. But whatever procedures you set up, make sure you follow them, and make sure that your ministry leadership is in agreement and willing to invest in the decisions and the policies you make and support it. So here are just some basic child protection policy information that you want to include. One of the very first ones, and we say it a lot, but I think there's still a lot of it's not going to happen here, things where a lot of times in ministry, we don't want to do this. There's a cost involved. But one of your best ways to defend against some type of sexual misconduct is to provide screening for employees and volunteers. We'll talk a little bit about what that involves, but you ought to have some screening. There ought to be a supervision policy for ministry participants. If they're going to be a leader and they're going to be leading your children or your teens or your vulnerable adults, you want to make sure you have a policy in place. A volunteer waiting period, we're going to talk about what that means and how you can incorporate that based on your ministry. You ought to know what the membership requirements and commitments are going to be, and you ought to annually review your policy and your workers. So when we talk about screening, what does that mean? You should screen all employees. So any of your employees should have a criminal background check done on them being employees. You also want to have all volunteers that are involved with children's ministry or vulnerable adults. Make sure that they've been screened. Initially, you want to screen everyone, not just new ones. So if you've never had a policy in place, then you want to make sure that you just go through and do everybody. And then you're also going to want them to fill out a written application, and that's true for all employees as well as volunteers. Now, occasionally I'll get questions like, well, how far do I go on this? If I have Vacation Bible School, it's for 1 week, and sometimes we have a handful of people who, that's the only thing they do. They just work with children during VBS. And I guess, ultimately, you have to ask yourself, what's the risk? If you bring somebody in, and you have to, I always say, put yourself in the position of having to sit on the stand in court and being asked, well, why didn't you do this? Are you going to be able to explain it well? So if you have a VBS and you've got adults who are only with them that time, is it really worth it to go through and have them fill out an application and do a background screening? Well, it's easy to say no unless something happens and it was with that one person that you didn't screen because you didn't think it was that important. So it's not, I don't say that as a scare tactic. I just say it's not that there's an absolute black and white rule on this, but I would tell you that it is something you want to consider anytime you have someone working with children or teens or vulnerable adults who may not be able to speak for themselves. Your requirement goes up. Another thing you want to do is you want to request at least 2 references, and those references shouldn't be family. Again, if you're a smaller church, those 2 references you may know them because maybe they've worked, they've been part of that church and that for years. But if they're a relatively new individual, you should make sure that you have references and then actually check them. Don't have them put down 2 names and, it just so happens that one of the people that they had down there was a probation officer, but you never bothered checking. So if you have references, you want to follow that up. I usually encourage that you conduct personal interviews. Quite honestly, people can write anything they want on paper, and they can even make it through criminal background checks. But when you have a personal interview, you all know there are always individuals within your ministry who just are able to read people well. They're going to know if they get a gut feel that just doesn't seem like something's right, or maybe there doesn't seem like there's a lot of maturity or discretion. So have a personal interview. You don't have to berate them with questions, but you want to have, it can be a friendly, courteous, back and forth conversation, just asking them about their experience, why they want to be involved in children's ministry, and then willingness to ask some of the basic questions. And then you want to do background checks on your employees and those volunteers, especially the ones that are working with children or youth or vulnerable adults. On the application form, we have, again, sample examples of this both on our website and also in a number of our materials. So we have sample forms. You don't have to create it from scratch. And the whole reason we do that is so that we can make it easier for you. Some of the things, if you're going to do it on your own, you want to make sure that it has personal information and references, allows a criminal history check, asks them about sexual misconduct and whether they've ever been accused of sexual misconduct, and then making sure that you authorize. You do have to get their authorization in order to do background checks. So these are things that you would want to include on the application form. When it comes to background checks, you want to conduct those on the employees and volunteers. You want to use a reputable and accurate company. There are a number of companies out there that provide background checks. A lot of your denominations can give you names that they would recommend. And then if you get those results back, you want to make sure that you take them seriously. You know, you're going to get a lot of information. You'll certainly want to keep any of that background information in a private file locked with limited access. But if there's something on there that gives you pause, whether it's sexual misconduct or some other type of situation where they shouldn't be involved in children, you do want to take those results seriously. You don't want to, you know, blow them off or downplay them, and then if something happens, again, you're sitting in court or you're taking a deposition and you're having to explain why you ignored it. With a supervision policy, we have what we call the 6-month rule. Now again, there's nothing magical about 6 months. To require individuals to be involved in ministry for at least 6 months prior to allowing them to work with children is really an indication of how well do you know them. Again, it's not that you can't ever have less than 6 months, or for instance, one time I was talking and I had a college church and they said, well, if I wait 6 months, they're going back from college. Well, then you have to come up with some other ways to do it. But the reason we suggest 6 months is because at that point, you've had an opportunity to see, are they reliably attending church? Are they making mature decisions? Are they interacting with minors in an appropriate way? Are there any flags that maybe you should know about? And so you know, it's really just having that 6-month rule of getting to know them. You want to encourage them to participate in special training because it's broader than just sexual misconduct, but things like CPR or first aid. And then making sure that your supervisors can maintain control of a group. So this isn't just unique to sexual misconduct. This is about general supervision whenever you're dealing with youth. You want to make sure you have enough number of supervisors and keep state ratio requirements in mind, especially if you're talking about really young children. You know, that's true. I work with a bunch of junior hires on Wednesday nights, and I know, you know, some of the most difficult times to make sure you have all those supervisors are when, you know, you're going on trips and you've got a bunch of people in a van or a minibus. Or when you have a Sunday morning and 3 people call in at the last minute sick, maybe you need to combine classes or get other supervisors to make sure that you have enough people in there. And that's why we talk about having at least 2 unrelated adults at all times, or not leaving somebody alone with children. This is to protect your adults as well as the children. And the reason we say or we recommend unrelated doesn't mean that you can never have a husband and wife serving together in a ministry setting. But if there is a claim made against one and the only other adult in there was the spouse, it pretty much takes some of their credibility away. You might want to have activity participation agreements and require supervisors to report injuries or disciplinary actions so you know if somebody's upset about something or concerned. Communicating risks of child abuse to the congregation. You need to make sure that if you have a protection plan, that your congregation and your leaders are aware that you have it in place. Again, it doesn't do you any good if it's behind the scenes and nobody knows that you have a policy in place. And make sure that if you have some hesitation, some people go, you know, I don't think it's appropriate to ask these questions, or I don't think you should be doing a background screening on me. Do you not trust me? You need to be clear that you're trying to protect them as well as the children, but also the ministry. And then make sure that if you make changes to your policy or you modify the program, that you communicate these changes as well. So I'm going to answer a couple more questions that have come in, and then I'm going to address an issue that we often get questions on about in today's world, what do we do if we have sex offenders in the church? But one of the first questions I'm going to get is, what should the application for volunteers consist of? What types of questions, just vital information? And so this is where I would probably point you to our website. We have a sample agreement of an application, and it talks about all types. It has a number of questions. It's not complicated, but it does have some basic information, some basic questions that you can ask so that you've at least done your due diligence and done your best to protect somebody. So check out our website. I think they'll also be talking about some other resources at the end. And so, but that's one of the things that you can do, is just use a sample application. Another question is it typical that references are requested and followed up on for volunteers? Well, I did talk about that. I mentioned Vacation Bible School in addition to a personal review. It says we have background checks for all of our volunteers. So references, you know, again, I think you need to tailor it to your organization. I think some of that depends on how familiar you are with the volunteers that you're using. If this is somebody who's relatively new to your church, you're going to want to consider references. If, for instance, the example I gave with the college church, one of their recommendations I said is, well, then you need to go to contact their previous pastor church and get a recommendation that they had worked at that church for over 6 months, or had volunteered for that church for over 6 months, so that you're not getting somebody that you don't know anything about. That's really the purpose. And so I think that those are some of the questions that we've asked on the sexual misconduct piece. So I'm going to go ahead and make sure that we don't run out of time to talk a little bit about dealing with sex offenders in the church. Unfortunately, this is one of those things that we get a lot of questions on because you don't really think about it. But nowadays, with all of the sex offender lists, I can pretty much guarantee you that there will be people out there, if there is a sex offender in your church, somebody will know about it and you will hear about it. And so what happens is we get these questions about, how do I balance our love and grace for redemption with somebody, you know, for somebody who's made mistakes in the past, with the safety of those who are coming to our church. And so we want to be able, you know, a lot of times they're like, well, can you do both? Can we protect the innocent and also minister to the fallen? The answer is you can, but you have to be very careful and cautious about how you do it. I often reference Rich Hammer's Points to Ponder on some of the best reasons why, or some of the ways that you can look at doing this. And some of the things that he talks about is, first of all, there are different types of people who are sexual misconduct offenders. But if you have a molester of a pre-adolescent child, they should be considered incurable and highly promiscuous. The recidivism rate is extremely high when you're dealing with pedophiles, and you really don't want to take the chance that you could be in a situation where one of your children could be harmed because you gave grace. You want to check someone's criminal records. If they have a probation or a parole officer, you should contact them, get their permission. If they are truly wanting to move forward with their life, they've paid the price, they made a mistake maybe when they were 17 and now they're 34, you know, there are lots of different situations. You can contact it. They're going to want to do whatever they have to do and they're going to understand why you're asking questions, and they're going to want to protect themselves as well as others. So if they have a probation or parole officer, you should talk to them. The public's no longer going to tolerate ministry allowing a convicted child molester to come in and be part of the activities with the church and then just say, well, but we wanted to show grace and love and compassion to that person. That's something that's not probably going to be tolerated by the members of your church, but also if something was to happen in a court setting. Also, if you don't restrict a known sex offender, you could expose your church to punitive damages. And these are excessive, significant. When you hear the really large awards that are made in lawsuits, a lot of times it's because of the punitive damages. And so really what we talk about is that churches have three options, and we're going to talk about this a little more. But you can, if you have someone who is a sex offender who wants to participate in your church can do nothing, which we certainly would not encourage. You can have what we call conditional attendance, or you can exclude them and just say our church is not prepared to handle this situation. Another thing to make sure that people are aware of is that church board members can be held personally liable for gross negligence. So if the church board members, not all of them even, if just some of them knew that there was a sexual predator in the church and they were being allowed to participate, and then something happened, they could be held personally liable. And they should consult their insurance coverage to determine coverage for potential claims. Going back to punitive damages, nearly every insurance company or insurance policy is not going to, in fact, in many cases, state laws won't permit coverage to be provided for punitive damages. And then you're going to want to make sure that you draft a policy about how your church is going to handle sexual predators in your church. So if you decide that you are going to allow them to attend or participate, make sure that you have a written response and then have it adopted by at least the board or whatever your trusteeship is, make sure, and then that it's communicated to the congregation. So as I mentioned before, one of the options is that you can do what we call conditional. You can allow conditional attendance. And in that situation, you will allow a sex offender to attend your church, but you may have specific restrictions, or you may have to do specific things in order to protect the church. So one thing is that you would have written policies with specific restrictions, such as their off-limit areas. If you have a sex offender, it may be that they're allowed to be on church premises, but they are not allowed to use the restrooms. They're not allowed to be in the children's area. Or maybe they can come, but there are certain restricted programs or functions they're not allowed to attend. They're not allowed to come for VBS. They're not allowed to come to a children's program or things like that. The third one is another option is to have what we call chaperone requirements, or assigning a sponsor or mentor. These are individuals who are aware that they are sex offenders. They are mature people within the church who can come alongside, and they are with that person all of the time. So a lot of times the sex offender is a parent, and so what you have to do is you have to have somebody, not their spouse or but actually an assigned sponsor or multiple sponsor or mentors who they have to be, if they're going to be on site at the church, they have to be there with them all the time. Another thing is you may encourage or require that they have regular professional counseling, or that they participate in a support group. And these are all things that you can do. I know one organization that actually ministers to not sex offenders, but to convicts. They have a special service on like a Thursday night. So it's a night when there aren't children's activities around. And so they have a special service just for convicts. And that limits their, that still gives them the opportunity to work with, to fellowship, to have that interaction, and yet it still protects those who are most vulnerable. And so that's an option that I've seen some churches do. But there are many others. Again, there may be something that's unique. If you have a church of 70, you're going to have a different type of restriction or policy than a church that has maybe 7,000. And so as you go through this, you're going to have to decide what you're going to do. It may be that you just don't have the resources necessary. You don't have enough people to assign sponsors or mentors. You don't have somebody who can, there's so many activities that you have. Your church is open 7 days a week and there's something going on every night, and it would be almost impossible to restrict their programs or when they could be there. And in that situation, you may just need to say, I'm sorry, you're not, we would encourage you to go to this church instead. They have this opportunity, or they have a policy in place that would allow you to worship and yet would also provide the protection that's needed. Some of the things that we have, and this is as I've talked throughout this whole thing, we've talked about different resources. And so there are a number of them that you can get on our website at brotherhoodmutual.com. And then you can kind of look through. There's a lot of information on there to give you things so that you don't have to start from scratch. One of the benefits, because we insure over 50,000 different ministries across the United States, we see it. Unfortunately, we see the good, we see the bad, we see the really creative ways that churches are tackling some of these issues, and we also see when things aren't done well. So these are ways where we've been able to create things that would work for, that might work for you, or that you could at least look to, and it would help you make wise decisions. I'm going to go to see if there's a couple more questions that we would have. One was, what background checks do we recommend? There are so many different options and packages. Again, I think that's unique to your organization. There may be a situation where it makes sense for your denomination would recommend someone. There are a variety of background checks out there. Some of them are local. I would certainly encourage you to do the broadest one that you can afford. But again, every ministries are on limited budgets, and so we recognize that how much limitation you can do. Another question that I often get is, how often do we need to update those? I encourage that you do a background check at least once every 5 years, if not every other year. That I would have them sign the statement or fill out the application annually, or at least attest to the fact that nothing's changed. So that's another question. So at this point, I'm going to turn it over to Dan to take us out of here, and I appreciate your time and attention this afternoon. Thank you.
Yeah, thank you, Kathleen. Good information today, and we'll just go over really quickly. You mentioned it during your presentation. It's called Working Together. It's an employment practices guidebook. It has more than 70 pages of best practices, sample forms and policies, and also tips for preparing an employee handbook at your ministry. You can download a free copy at brotherhoodmutual.com. You just type that in and search Working Together, and I've also dropped the link into your chat window a few times throughout today's presentation, and you'll get a follow-up email that has links to that resource, as well as the slides and the recording of this webinar once the recording is ready. So you'll have all that in your email box probably within a week once everything gets uploaded and ready to go. We are coming up toward the end of our scheduled time. Before we finish, we'd like to remind you also that we offer a wealth of risk management resources like Working Together on our website, brotherhoodmutual.com. You can also stay up to date on our latest content by following us on social media. We're on Facebook. We're also on Twitter at BrotherhoodINS, and we are on LinkedIn. Again, thanks to Kathleen for her time in presenting. Thanks to everyone out there in the audience for participating. Have a great day.